Welcome to the Real Estate Prosperity Podcast. My name is Robert Metz, and I'm the author of the just published book, which is entitled Real Estate Prosperity. It is presently available in both e-form and hard copy at www.realestateprosperityllc.com. This is one in a series of podcasts which are designed primarily to really teach you, how to create equities, how to create a substantial cash flow, how to make real substantial money by flipping, speculating in, or long-term investing in, and rehabbing real estate. No nonsense, no silly schemes or get-rich-quick formulas. Just hard knowledge, proven methods, and expertise. Real roadmaps to enable you to function and succeed in the real world. There is a tremendous amount, an incredible amount of money to be made in what is commonly referred to as foreclosures. But to really succeed, you do need an understanding of the basics, the methods, the terminology. You need the underpinnings. You need to know how to navigate, not just the conclusions. The world of foreclosures is almost limitless in its potential. I'd like to cover initially some basics on the foreclosure process. Again, obviously you can buy a property in foreclosure to either hold it for the longer term or to flip it. You can succeed in foreclosure real estate in any market, whether you are buying, selling, holding, flipping, renting, rehabbing, whatever the case may be. You can either buy the property, the real estate itself, or what in the industry and the business is commonly called a paper. Both methods can give you huge success on the quick turnaround or in accumulating equity and creating cash flow. Buying the property is self-explanatory. Buying the paper is a little more exotic or intricate. I shall explain it more in subsequent podcasts, but it's basically buying the mortgage and the note that are in foreclosure, or even before they go into foreclosure, depending on the transaction. You, in effect, step into the shoes of the lender who is foreclosing. You become the lender, and it is your goal to buy and or in some fashion to control the property, to control the deal through the mortgage, through the paper. The key in buying real estate in general, and particularly foreclosure real estate, is to have what I call built-in upfront equity on day one. Built-in upfront equity. You have to buy low, buy right. Your margin has to be there immediately, either clearly in terms of the numbers or in terms of the actual potential in clear, verifiable form. A deal must be there. You must see that something extra. Over the years, in infomercials and more commonly today on the internet, there have been scores and scores of what I call hucksters preaching their no knowledge, no money, no credit, no effort, no nothing schemes by which you can make fortunes in foreclosures. If that is your goal, you're going no place. There's no magic, but there is enormous, enormous potential. You need the knowledge, prudence, effort, perseverance. You need to know the methods. And yes, you do need money and or credit, whether it's your money or credit, your partners, your banks, or indeed whether the money and or the credit is pre-existing in the property that you're trying to buy, the property that's in foreclosure. Because plenty of properties in foreclosure do have equity. They do have assumable financing. So many times your money, your equity, your credit, for the most part, can come from the deal itself that you are looking to buy, to control. Generally speaking, a foreclosure action, where the lender is looking to retake the collateral, or I should say take the collateral, in satisfaction of the debt from the defaulting borrower, is called, again, in rem, I-N-R-E-M action. Latin legalese for an action, a lawsuit, affecting a piece of real estate. The garden variety lawsuit, whether it's suing somebody for damages in a slip and fall case, or whether it's suing a defaulting former borrower for a deficiency judgment where the property in the foreclosure action does not cover the entire debt, a personal action against an individual or a company, say an LLC or a corporation, is called an in personam action. Again, Latin, an action against a person. In a foreclosure action, the plaintiff is a lender who is owed the money. The state rules about the proceeding of a foreclosure action vary, and the states are typically referred to as strict foreclosure or judicial foreclosure states, and there are others. A judicial foreclosure state, such as New Jersey and most states, is a state where the process follows through the court system, and it's a closely monitored, precisely laid out lawsuit, litigation, aka foreclosure. There's certain common basic facets, basic elements of all foreclosure cases, however. In the first place, you have to have a default in the mortgage and note terms that is left uncured by the borrower. The default can be a failure to make the mortgage payments, pay the real estate taxes, insurance, properly maintain the property, or the default can even be renting a property that's not supposed to be rented, being in violation of municipal or state property code requirements. Default can take a lot of forms. Typically, of course, it's monetary non-payment. In the event of a default uncured, and typical mortgages give 31 days in which the borrower can cure his default before the lender can declare that it's in foreclosure. The lender, to declare a property in foreclosure, says he is accelerating. After the 30 or 31 days, he does not have to immediately, but he can at any time accelerate the mortgage. Acceleration means he advises the borrower that the entire mortgage debt, all unpaid principal, interest, any kind of arrearages, outstanding taxes, miscellaneous fees, legal fees, late fees, everything is due and payable at once. If the mortgage has another 30-odd years to go, if it has another 30 months to go, everything is due immediately. The lender declares the acceleration of the mortgage. If the borrower does not comply, the lender proceeds with the foreclosure action. Certain statutory and courtesy notices are sent. Then the lender files what's called a lis pendens. A lis pendens, L-I-S-P-E-N-D-E-N-S, is a certification filed by the lender in the local recording office where real estate related documents and notices are filed, typically the county courthouse, the county register of deeds office. What the lis pendens does is it cuts off subsequent potential lien holders to protect the existing lender's position as he pursues a foreclosure action. For example, once a lis pendens is filed, if the existing owner, the borrower in default, decides to sell the property to a third party, if he's in a position where he can in fact borrow additional money, a second mortgage, a fourth mortgage, whatever the case may be, if he's getting work done and the mechanic places a mechanic's lien or a mechanic's notice of intention on the file, if a judgment is rendered against the property owner, once a lis pendens is filed, all of these documents, a fully executed and recorded deed to a third party, a new mortgage duly recorded, they're all meaningless. They do not affect the property because once a lis pendens is filed, as the legalese terms it, the world is put on notice as to the pending foreclosure action, and anybody else who thinks they are obtaining, whether it's for consideration, whether it's for dollars or otherwise, a lien, an interest, a right in the property, they're getting nothing, because once it goes to get recorded, even if the recording office accepts the document, even if they accept that new easement or mortgage and record it of record, if it's recorded after the lis pendens was recorded, it's zero. It's a worthless document. It does not put a cloud on the title, and it gives no rights. It gives nothing to the party who received that document, who received that mortgage document or deed. It's meaningless. And that protects and preserves the position of the foreclosing lender during the pendency of the foreclosure action. So the foreclosure action is a lawsuit against property, an in rem action. It's initiated with the filing of the complaint, the lawsuit complaint, and with service of the complaint upon the defendant, namely the defaulting borrower, and any third parties named in interest. Parties which are called junior lien holders are typically, or should be, for the lender's protection, named as co-defendants in the foreclosure action. Superior lien holders do not get named. For instance, if it is a second mortgage foreclosing and there's a first mortgage on the property also, the second mortgage does not have to name the first mortgage in the foreclosure complaint, because by definition, a superior lien holder, meaning a lien which has a position superior to or prior to the foreclosing lien holder, they're protected. It doesn't matter if they receive notice, because the secondary lien holder, even if the secondary lien holder is a first mortgage and the superior lien holder is the IRS, whose tax lien comes first, or the municipality whose real estate tax lien would come first, the superior lien holder is not affected, he's not hurt. It's only the junior lien holders who have to be joined and put on notice in order to effectively eliminate their interests in the connection with the foreclosure. If a second mortgage holder, even if his mortgage is current, is not put on notice in the foreclosure action by the first mortgage holder, by the first lien holder, his mortgage could survive the foreclosure and he could still have a valid lien or interest in the property. So if a first mortgage, kind of your garden variety foreclosure, is foreclosing, he will typically name the second mortgage. He may name superior lien holders, but it's not necessary. He would name any secondary lien holders who might have a mechanic's notice, judgment holders of record, mechanic's liens, recognizance for things like bail bonds, easement holders, tenants with recorded leases, unknown tenants or unidentified tenants who may or may not have a valid lease. They're all named as junior lien holders in the foreclosure complaint, and they all need to be served in a precise way, in a stipulated way, by the foreclosing lien holder or their attorney with the complaint and the summons. After everybody is served, the lien holder who was foreclosing will want to have done a second title search, primarily to avoid any complications from what is commonly referred to as a midnight sale of the property. Even if it might be ruled invalid down the road, up front, the foreclosing lien holder wants to know whether or not, and he needs to know, whether or not the property owner, the borrower, has secretly or quickly gone and tried to sell the property, tendered a deed for consideration while papers were in the process of being recorded to some third party. So, everybody having been served with a complaint and summons, the foreclosing lien holder does his second title search, and the matter proceeds. The defendant, namely the borrower in default, and indeed any other lien holders who are named, can file their answer to the foreclosure complaint and a counterclaim. Again, that has to be served in a certain way on the foreclosing lien holder and all other junior lien holders who may have been named in the foreclosure complaint. Any answer and counterclaim having been filed, the clock starts running. If, in fact, no answer or counterclaim are filed, after a stipulated period of time, a default can be entered by the foreclosing lien holder, and the case proceeds to its next step. If the foreclosure has been contested by an answer and or a counterclaim, then the litigation proceeds in terms of discovery and other aspects of a normal litigation as between plaintiff and defendant. In the course of the litigation, there are a variety of notices and opportunities to cure, points of contact between foreclosing lender and borrower.